Good morning, good afternoon. In this call, we are more good afternoon people or even good evening people. I am Marco Buscema. I'm an Italian attorney. I live and work in Udine, northeast of Italy. And I am a personal injury attorney myself. And I am the proud founder of WIL, Worldwide Independent Lawyers League. Every week, we have different slots. And one is what is on my desk on Tuesdays, and one is the World of Law on Thursdays. Today is Thursday, so we have an episode of the series The World of Law, where people speak about a specific topic or a specific area of law. And we can have internal speakers, internal WIL affiliates, or guests or external ones. Today, we are proud to introduce one of the most active affiliates in sharing his knowledge, Rahul Hingmire, or as I use normally the English pronunciation, Hingmire. I don't know, it sounds American or international, but okay, I respect what Rahul tells us and tells me. Corporate lawyer, very active, owner at Vis Legis, structured a law firm in Mumbai. The strength of law. Vis Legis is Latin, and I should be familiar. I am familiar with this because I'm Italian, and at the university, also the schools, we learn Latin as well. Vis Legis, the strength of law, India's legal evolving landscape. Today, the title of this session. Rahul, to you for the next, let's say, 15 minutes, letting also people then to interact with you for a short Q&A session. Thank you.
Sure thing. Thank you, Marco, for the opportunity, and great to have all of you. Looking forward to your inputs towards the end as well. I'll be taking this subject to indicate and inform you that in last decade, India's legal system has gone under dynamic transformation, marked by introduction of various new laws, also amending existing laws, as well as repealing some of the outdated statutes that we have seen. Now, these changes reflect India's very much keen efforts to align our standard of practice, our efforts to get global best practices also aligned to us. These changes also tries to balance the domestic social economic challenges as well as demands. And ultimately, the modifications, amendments, and introduction of new codes are also to ensure that we create business-friendly environment in India while protecting the interest of all the stakeholders, including India's citizens and domestic business owners as well. So whether it is simplifying the tax structures or enhancing the data protection or bringing more comprehensive solutions towards insolvency scenarios, India is trying to create impactful provisions which are going to shape India's journey for to come and to become as one of the emerging global powerhouse. With that intent, I want to take you through this quick presentation to see what are the key highlights that we have for last one decade's evolution in India's judicial landscape. Now, we all know India is a diverse legal country, and so is the legal framework. India's legal system, rooted in colonial history, is heavily influenced by English common law. But also, we also have various set of unique local custom and statutes which kind of take care of the unique requirements which we may have across India. Many of the Indian newly introduced commercial laws like insolvency bankruptcy or goods and sales, goods sales and tax, service tax, or if you have to look at the new amendment in Companies Act, they are efforts to integrate again the global best practices while addressing the local business dynamics. We also often see judiciary often interprets laws flexibly, that is to balance the strict statutory provisions with equitable solutions to address India-specific socio-economic challenges. We have also seen active judicial activism where the Indian courts often interpret laws expansively to fill gaps where legislative actions are lacking, influencing the economic policy and protecting the interests of all the stakeholders again. cases where India's Supreme Court has been time to time trying to explain the intent of legislator in better manner, trying to bring clarity, and also, if needed, striking down certain provisions with an intent to showcase that India's judicial interventions are also needed at a times to safeguard the interest of all those involved. While promoting fairness, such interventions at a time sometimes can become little bit of unpredictable circumstances, especially for the businesses who are used to having a rigid systems. So those situations can certain times bring some level of unpredictability. Now, we often see when we talk about India's judicial legal system and scenarios, we get to hear about long litigation timeline and many of the aspects which discourages a lot of parties from exploring India's judicial system as a solution for their legal problem. Rightly so, we have around 40 million cases which are pending across Indian courts, but there are efforts made to bring them to early solutions. We have now dedicated Commercial Court Act and bringing commercial courts benches across metro cities as much as possible. We are also having various new tribunals being established, incorporated to solve the expertise set and very unique demand in terms of judicial adjudication requiring scenarios to go about. Uh, Although we have many of the things which are in plan and still many of the things are getting established as we speak, the commercial courts are definitely trying to do the needful to ensure that those who are seeking courts assistance are getting timely intervention and judicial uh, disposal for their cases that are there that are placed before the courts. At the same time, I must share mediation practice has been brought in, which has become a mandatory step before any commercial dispute can be taken into adjudication process to go about it. That itself shows how India's, even executives who are bringing legislations as well as the judges who are actively recommending and advising and encouraging parties to explore mediation as an alternative method to go about it. Talking about arbitrations as well, we've seen arbitration practice has increased extensively in last 10 years. Although the data of ad hoc arbitrations are not very much available in terms of statistics, but when we compare the institutions pertaining arbitration proceedings data between year 2009 to 14, India was merely having around 1,000 arbitrations getting referred to arbitration centers of between Delhi and Mumbai. And if we compare that data to today, in a year's time, around 8,000 arbitration proceedings are getting recommended or referred to the institutions. Now, we see 8 times growth in last 10 years' time, which shows that more arbitration preferences have been seen by various parties. Now, talking about influence of culture and informality, India's culture emphasizes business relationship, but with the for informal negotiation, and often the mediation takes precedence when it comes to getting involvement of community-based or caste-based business associations. So many a times before the issue or dispute lands up in court, one round of negotiation or settlement approach has already been applied to it with the interference or with the intervention of some of the business community based association or specific industry specific association also. So there is a mindset that people want to have solution. They see judicial intervention as a litigation as a last resort to go about it. I must also introduce a term called Jugaad. Jugaad is nothing but a innovative way to solve a problem with out-of-box thinking. We always try to find some or the other Jugaad's solution in our approach to go about it. And when I say we, I mean typical Indian party who is about to go into any kind of litigation. Uh, so influence of these cultures also try to enhance and try to expedite the things to go about it. Uh, because it's a country which has many different states, different regions, a vast population, we also have different requirements, right? So diverse jurisdictions are also a natural byproduct of all this diversity. As I mentioned earlier, we have separate courts, National Company Law Tribunal, Security Exchange Board, then Competition Commission, Green Tribunal. These are different boards which are having domain specific cases that are going in, and these courts are trying to solve the industry specific problems by applying their expertise to go about. However, all of these tribunals ultimately uh, can get scrutinized by the apex court, the Supreme Court, which ultimately holds the superior authority to review their judgments to go about it. And at a times we see that there are many times a situation whether the issue can be taken to these forums or it needs to go to courts like High Court or Supreme Court directly. So in earlier periods, a lot of cases were taken up to Supreme Court or High Court just to understand whether the dedicated forums are good forums or not. But nowadays, we see lesser and lesser number of those cases because the judicial rulings as well as the clarification in laws are making those things very clear to go about. And we also see in multiplicity of laws and forums, earlier in time, if bank needed to recover the loan amount which was defaulted by the borrower, bankers had multiple options, lenders had multiple options to go about it. But with introduction of insolvency bankruptcy code, simplification has been achieved to some extent, and there is one forum, that is National Company Law Tribunal, to go about it. So earlier, what used to be like a forum shopping, which was a common tactic to get parties to get the orders from the desirable courts. Now it is not possible so easily, and there are dedicated courts and forums that are taking up these cases to go about. Further simplification efforts are also being observed where uh, indirect taxes pertaining laws were multiple. Now that has been brought under GST, that is Goods and Service Tax Code, which is unifying to simplify the compliance part to go about it. India is still settling down with this introduced law, which was in 2017, but definitely it is a move towards simplification of the compliances aspect to go about it. India has unique concepts, which is like public interest litigation. Many a times, the intended objective is sidelined, and some other intent is presented where they will stop a commercial project under the pretext of it affecting the public interest at large. But Indian courts, Indian judges of high courts and supreme courts are getting better and better at it, and they are trying to restrict the use of public interest litigation to a very limited extent and allowing commercial as well as public infra projects, large scale projects to proceed further smoothly. We also seen introduction of insolvency bankruptcy code brought in a new process, that is corporate insolvency resolution process, which allows a sick company to stay in action, in motion, without it getting declared as a entity not to be dealing with businesses and all, which also brings more opportunities for it to be revived by having a new management and new buyer coming in. Uh, in initial period, we experienced delays and all. However, with clarity coming in, with more amendments coming in insolvency bankruptcy code, we see better and better utilization of this method to revive the companies which are about to go become insolvent to go about it. Uh, there are some interesting cases that we have seen in past. The big names like Vodafone, where they were levied heavy penalty because of a retrospective change in tax laws, tax policies, which was heavily contested matter. Not just in till Supreme Court of India, where the decision was against Vodafone, it also ended up going into International Arbitration Center, and that's where the Vodafone company managed to get a favorable order, and it kind of the International Arbitration Tribunal ruled in their favor as well to suggest that the retrospective tax policy, which was introduced by Indian lawyers, Indian tax authorities, was in violation of India-Netherlands bilateral investment treaty. After understanding this, not only Indian legislators repealed that law, that amendment, but also taken up a step towards rebuilding the confidence for the investors, demonstrating that India's commitment is towards fair and clear tax regime to go about it. We also have heard about this famous airline Jet Airways. Due to them not being able to manage their outstanding dues, it went into liquidation. It went into insolvency proceedings, and CRP process was one of the tool which was taken up by many of the foreign investors to revive this airlines to go about. It is still in work in progress scenario, although one consortium emerged as a successful bidder. However, time will tell as to when Jet Airways will fly again. This is the same airline in which Etihad Airways, one of the famous UAE airlines, has stakes in that. Last case study, a very famous name across world, Amazon. Amazon and Future Group had entered into a transaction which was to do with a future scenario based Amazon's right to acquire Future Group. Uh, However, Amazon never exercised that option. And when India's one of the biggest conglomerate called Reliance Industries, they decided to pursue this acquisition of Future Group. Amazon stopped them from doing that, invoking their contract. Now, this is an interesting case to share because Amazon invoked Singapore-based arbitration clause and took that matter into arbitration. At the same time, Future Group approached to Indian courts, and we ended up having sort of contradictory judgments to go about it, where India's Competition Commission of India cancelled the Amazon's right to approach and invoke the investment clause. Ultimately, the intended party who was trying to take over Future Group sort of withdrew itself from the entire bid. However, this conflict scenario kind of showed that there can be a scenario where Indian courts can go contrary to the Singapore courts or many of the other rulings to go about it. However, now with adoption of best standard practices, even Indian courts are becoming mindful as to how to treat arbitration scenarios and investment contracts and transactions to go about and to protect the shareholders agreements or any investment agreements for from getting it affected by contradictory judgments. Now, many of the situations, many of the modification in laws are being done to ensure that any foreign direct investment coming in, flowing in India is not misused or mishandled or not causing any kind of problem to not only to the investor as well as to the domestic players. So defense sector and e-commerce sectors are highly regulated when it comes to foreign direct investment. However, there are many other sectors in which 100% foreign direct investment on a via automatic route is allowed. We also see many minor offenses which were there under Companies Act were amended to kind of regularize to allow better, efficient way to go about adopting it to attract global investors via Companies Act amendment in 2020. Lastly, technological adoptions. Post-COVID, India has been very aggressive in adopting technology in all possible manners. Indian courts have adopted virtual hearings, digitalization of records, as well as enhancing accessibility to the courts records via various medium. I must share that 18,000 courts have adopted the e-court system, because of which now any of litigants can access court records, parties matters, details across India to go about. 18,000 is a big number, and to digitalize these many courts is not a small task to go about it. Uh, India's e-court project is towards creating a paperless court system. Many of our matters, many of our court proceedings, including High Court, where Harish sir and I practice, it doesn't require physical filing as a primary step. First step is now filing a digital version of the court proceedings to go about it. We are also having many AI-driven tools getting adopted. Contract management and compliance is a normal thing across globe. We see that. However, Indian judiciary is also very bullish about adopting many of the tech in their active day-to-day activities. We see Delhi High Court being very aggressive in bringing technology, and some of the smaller courts, smaller high courts like Ranchi High Court also has experimented in adopting AI technology to see whether it can assist judges in coming to early conclusion, doing necessary research within the case to go about it. A quick summary and quick review of significant legislative changes that we have seen in last 10 years. In 2016, we got adoption of enactment of Insolvency Bankruptcy Code. 2016, again, we saw a dedicated act coming for real estate scenarios. 2017, we saw GST. 2021, we saw a repealing of a Farms Law, Farmers Act was brought in 2020, and amendment in Companies Act in 2020 again. Muslim law pertaining specific order was judgment was passed, and new law was enacted called Triple Talaq Act. Prior to this law, by merely pronouncing talaq, which is nothing but divorce as a meaning word in Urdu language, if male spouse happens to pronounce this word three times, it used to result into divorce scenario. And this act was brought in to restrict that kind of practice to protect the interests of women from Muslim community majorly to go about. Citizenship Act, Juvenile Justice Amendment Act are these acts which are brought in. Digital Personal Data Protection Act is been brought in, but it is yet to be operated. It has to become operational, but it is enacted. And recently, we've also saw replacement of Indian Penal Code, which was the colonial era Indian Penal Code Act, with modernized criminal laws under the title of Bharatiya Nyaya Sanhita Act. Now, I want to close this presentation with sharing something very interesting. Recently, we also got a new statue of Lady of Justice for us, wherein India's former Supreme Court judge led a movement where the new statue was introduced. In the new statue, you would see the blindfold is no longer there. The scales are balanced, and the sword has been replaced by Constitution of India. And our former Supreme Court Judge D.Y. Chandrachud, he emphasized that the law is not blind; it sees everyone equally. With that intent, we also saw this major change, which is a symbolic change. However, it says a lot, many things about in which direction India's judicial movements and judiciary is moving in. So, in nutshell, a decade of legal transformation in India with modernized legal framework focused on governance, with economic growth emphasis and social justice initiatives and digital integration. We see India's legal landscape has immensely improved and moved in a positive direction. Thank you.
Thank you, thank you, thank you, as we used to say in Warsaw, copyright of Justine, of course. Thank you. I took notes with this pen. Can you see it? Special pen, and that's also Will. That was a present of Sanjay Patel in the last Mumbai Asia Pacific meeting last year. I think we can go back to this because it's very nice. So we have let's say 5 minutes for Q&A. So if you want some, I saw Maximilian enter the room, and also Kalyani from Mumbai, another colleague from Mumbai, and then think about an interaction with Rahul, Maximilian, and Kalyani, and then you can also take the chance to introduce yourselves. I break the ice here. I am always interested in languages, no? And India has many languages, many communities, and I got that Hindi is like English in India. You use as a third language to communicate between states and between different people. So my question is, I know that in some courts, high courts, English only is allowed for documents, I mean, legal notices, answers, writs, affidavits, what on. But in lower courts, also other languages are allowed, also local languages. So what if when from Maharashtra, where you speak, of course, English, Hindi, and Marathi, you have to act in Bangalore, in a lower court, where Kannada could be the language. Are you allowed to use Hindi, for example, or English also in courts where you can use local languages? So how would you go there? Would you act in Bangalore or in Chennai, where I think Tamil is the language?
Sure. So, Marco, in India, we enroll ourselves with certain bar council at state level. So, I'm member of Bar Council of Maharashtra and Goa, which operates within the two states, where I should be familiar with the local language, where I am enrolling myself as a practicing lawyer to go about. And if I enroll myself, then I can participate in proceedings with a authority from my client to file case paper and paperwork to go about it. If I see your problem, the problem which you presented as a person from Maharashtra, if I have to go to Bangalore to attend any court proceeding, naturally I will not be able to be the advocate on record because I am not registered with the state bar. However, any local lawyer who is registered can file wakalatnama. That doesn't mean I cannot appear and argue. I can still appear and argue, but I will not have an excuse to say that I am not having a knowledge of the language. That's why you have to give me. Uh, I need to take assistance, but many of the courts across India are also are allowing certain pleadings to get filed in English. But that remains as a challenge at a times, which you mentioned. So if I get a local from the state pertaining lawyer to be an advocate on record, I can definitely solve problem for my clients and avoid problem for my clients to go about.
Great, great. Okay, very quickly, Maximilian, introduce yourself, and if you have a question, but quickly because we have a couple of minutes left.
Hi, everybody. Thank you, Marco. Thank you, Rahul, for your interesting presentation. Maximilian Breitling from Munich, Germany, president of Will Dach, specialist in insolvency and restructuring law in Germany, always dealing with insolvencies and restructuring cases. And my question is, do you know which system or which program or software tool was used to digitalize the court systems? Because we here in Germany, we have issues in general and in special. Let's say we are really struggling with digitalization of court systems, e-files, and so on. And we are on a very, very low level until today.
Max, I was in between disconnected. Can you come again with your question?
Which software or tools were used to start the digitalization of the court systems?
Okay, so these are not external tools except the ones for doing virtual hearing. I believe Cisco is one of the platform that has been used. Right, Harish sir? Cisco.
No, the government has come up with their own system. It's called NCIS, and different courts are for the purpose of virtual meeting. Different courts are using different platforms like Zoom, and some places they are using WebEx. But that is as far as the virtual hearings are concerned. Now, digitalization is done by the government itself with its own internal in-house developed software.
Mm-hmm.
So we need to figure out which, I mean, like we'll certainly, Rahul and I will try and figure out which software they are using and communicate back to you. But give us some time. Now, we will be breaking for summer, for Christmas holidays for a week, 10 days time. So after that, we should be able to get back to you as to what is the software which is being used. Basically, you scan the documents and email it to the registered or the designated email address provided by the High Court, and then they store it internally. They need it to be in a particular format, particular spacing, particular font, size, and A4 size. Now, earlier we were using legal size paper. Now they have made it compulsory for A4 size paper. So that's the change which our uniformity which they are bringing in.
Mm-hmm, mm-hmm.
And it's a great initiative because we have huge number of cases, millions and millions of cases are there. So storing them is an issue. And they are also digitizing the earlier records pre-2007, if I'm not mistaken.
Mm-hmm.
Right.
Mm-hmm.
Okay. Thank you, Rish, for your...
One more thing I would like to add is that the
okay,
stamp
quickly,
duty,
Kalyani, because we are ending the session.
The court fees also can now be paid online.
Correct.
Okay.
Yeah.
Okay, good. Well, good. I don't know if it's good or not, but fine. Okay. Thank you, Kalyani, for your note and your remark. So, Rahul, we are closing this session. A final takeaway from this evolving India's legal evolving landscape, please.
So, as I said, we are moving towards digitalization and modernization, and in all sense. And if any party has any situation, they can access to these details from any corner of the world now. Therefore, India is gearing up for better and more sophisticated way of handling your legal cases, and we are all there to support you on that. That's my final sharing and what you to take as a takeaway.
Great. Okay, so I greet all of you with this special pen, the flag of India, and it's also wheel here. I have to show it. Okay, thank you, Rahul, for your great, for sharing these great insights. That's the core of our alliance. Thank you to all the attendees, in specifically Maximilian Breitling from Germany, Harish Pandya from Mumbai, Justina Matukshak from Warsaw, Poland, Kalyani Sharma, still again from Mumbai, and Christine Lapaijan from Haifa, Israel. Thank you very much, and see you soon again on Wheel. Ciao, ciao.
Thank you, everybody. Bye.
Ciao, ciao.
Okay, bye. Good night.
Thank you, everyone.